Good day, ma'am. My name is John Victor A. Soriano, BS Criminology, Block 5. Today, I will recite the Presidential Decree number 968, series of 1976. Presidential Decree number 968, establishing a probation system, appropriating funds therefore, and for other purposes. Whereas, one of the major goals of the government is to establish a more enlightenment and humane correction system that will promote the reformation of offenders and thereby reduce the incidence of recidivism. Whereas the confinement of offenders, prisons, and other institutions with rehabilitation programs constitutes and one reuse drain or the financial resources of the country, and whereas there is a need to provide a less costly alternative to the imprisonment of offenders also who are likely to respond to individualized community-based treatment programs. Now, therefore, I, Ferdinand L. E. Marcos, President of the Philippines, by the virtue of the powers vested in me by the Constitution, do hereby order and decree the following. Section 1. Title and scope of the decree. This decree shall be known as the Probation Law, and in 1976, it shall apply to all offenders except those entitled to the benefit under the provisions of Presidential Decree numbered 603 and similar laws. Section 2. Purpose. This decree shall be interpreted so as to a. To promote the correction and rehabilitation of an offender by providing him with individualized treatment. B. Provide an opportunity for the reformation of offender with might be less probation of if he were to serve a prison sentence, and C. Prevent the commission of offenders. Section 4. 3. Section 3. Meaning of terms. As used in this decree, the following shall, unless the context otherwise requires, be construed thus. A. Probation is a disposition under which a defendant, after conviction and sentence, is released subject to conditions imposed by the court and to the supervision of a probation officer. B. Probationer means a person placed on probation. C. Probation officer means one who invested for the court a referral for probation or supervise a probation, and both. Section 4. Grant of probation. Subject to the provision of the decree, the court, after it shall have convicted and sentenced a defendant, and upon application to any time of said defendant, suspend the upon execution of said sentence, and place the defendant probation for such period and upon such terms and corrections as it may deemed best. Probation may be granted where the sentence, a term of imprisonment, or a fine only an an application for probation shall be filed with the trial court with notice to the appeal court. If an appeal has been taken from the sentence of conviction, the filing of application shall be deemed a waiver of the right to appeal or the automatic withdrawal of a pending appeal. An order granting or denying probation shall not be appealable. Section 5. Post-sentence investigation. No person shall be placed on probation except upon prior investigation by the probation officer and a determination by the court that the ends of justice and the best interests of the public as well as that the defendant will be served thereby. Section 6. Form of investigation report. The investigation report to be submitted by the probation officer under Section 5 hereof shall be in the form prescribed by the probation administrator and provided by the Secretary of Justice. Section 7. Period for submission of investigation report. The probation officer shall submit to the court the investigation report on a defendant not later than 60 days from receipt of order and of said court to the conduct investigation. The court shall be resolved the petition for probation not later than 5 days after receipt of said report. Pending pending submission of the investigation report and the resolution of the petition, the defendant may be allowed an temporary liberty under his bail filed in the criminal case, provided that in case where no bail was filed or that the defendant incapable of filing one, the court may allow the release of the defendant on recognize the custody of the responsible member of the community who shall guarantee his appearance whenever required to the court. Section 8. Criminal for placing on an offender on probation. In determining whether an offender may be placed on probation, the court shall consider all information relative to the character, antecedents, environment, mental and physical condition of the offenders, and available institutional and community resources. Probation shall be denied if the court finds that a. The offenders in a need of correctional treatment that can be provided most effectively by his commitment to an institution, or b. There is undue risk that during the period of probation the offender will commit another crime, or c. Probation will depreciate the seriousness of the offense committed. Section 9. Disqualified offenders. The benefit of this decree shall not be offended to those a. Sentenced to serve a maximum term of imprisonment and of than 6 years. b. Convicted of any offense against the security of the state. c. Who have previously been convicted by final judgment of an offense punished by imprisonment of not less than 1 month and 1 day or a fine not less than 200 pesos. D. Who have been once on probation under pro- provisions of this decree, and E, who are already serving sentence at the time the substantive provision of this decree applicable pursuant to 33 hereof. Section 10. Conditions of probation. Every pro- every probation order issued by the court shall commit condition requiring that the probationer shall a present present to the probation officer designated to undertake his supervision at such place as may be specified in the order within 72 hours from the receipt of said order. B. Report to the probation officer at least once a month at such time, and place as specified by said officer. The court may also require the probationer to A. Cooperate with a program of supervision. B. Meet his family responsibilities. C. Devote himself as I expect employment and not to the change and said employment without the prior written approval of the probation officer. D. Undergo medical, psychological, or psychiatric examination and treatment and entered and remain in a specified institution when required for that purpose. E. Pursue a prescribed secular study of vocational training. F. Attend or reside in a facility established for institution, recreation, or residence of persons on probation. G. Refrain from visiting houses of ill repute. H. Abstain from drinking intoxicating beverages to excess. I. Permit to probation officer or an authorized social worker to visit his home and place or work. J. Reside or premise provide and not change his residence without its prior written approval, or K. Satisfy any other conditions related to the rehabilitation of the defendant and not unduly restrictive of his liberty of incompatible with his freedom of conscience. That's all. Thank you.